Hey, welcome to another episode of Local Pro Town Hall. We've done several of these over the year, so 2024 has been really fun ride of having to learn new things and change the way that we do things and implement changes immediately when we might not know what we were supposed to do before, and now there's a new way, and then the new way just changed again. So we are going to discuss some of the changes that have happened just literally 2 days ago in our market, and we want to make sure that you are well informed. Oh, and by the way, don't listen to TikTok. Please don't listen to TikTok. Don't listen to Facebook. Question things. I read every night. I'm like, oh, that's not right. Oh, that's not right. Oh, why are they putting that out there? Well, there's a ton of negativity and there's a ton of misinformation. So verify before you spread that information. So here's one thing that is true that's coming up. So the Telephone Consumer Protection Act. So what it is it is a way for them to stop all of the cold calling and telemarketing. And please, I want the text messages for health insurance to go away so fast. So good news and bad news with that is, good news is it's always been there. Bad news is they're going to start monitoring it closely. And if you solicit calls to people that are not on the do not call list, the fine amount is insane. So that puts a little bit of a stressor on the real estate industry, because we always say, get on the dialer, call the people, call the people. But if they haven't given you permission to call them, then technically you're in violation of this act. So here's the thing, you're a local pro, you're a local expert. Get in your car and go meet the people. Go to a restaurant, go to a small business, go to a neighborhood event, go somewhere and meet people, and that's how you grow your sphere. Trina is a master of that, and she connects people, and then you don't have to cold call. I don't mind if you cold call, but if you cold call, you need to make sure that they've accepted that you're going to be calling them. So your sphere, people that you add to Lofty, there's a question when you're adding them to Lofty that says, has this person allowed you to call them? And you have to say yes or no. Have this person allowed you to text them? And you have to say yes or no. If it's your brother or your cousin, then obviously they will take your call. If it's somebody that you get from a school list, then that will not take your call. So there's a little bit of safeguards in place, but people jump over that all the time. I just want you to be aware that they are going to be cracking down on this a lot harder starting January 27th on 2025. Let's go. We have some more things. So welcome to the Department of Justice and the NAR fight. For several months, the reason why we started doing these town halls is because there was a settlement or a lawsuit that the judge needed to sign off on, which he did. And throughout this whole time building up to this, the Department of Justice was asked to review the settlement. So the night before the settlement was to be signed, the DOJ responds, and they say that the overview of what they said was that they feel like the settlement prevents buyers from even getting a no obligation showing without first coming to a written agreement. And then they also think that they feel like the settlement creates a barrier to market entry. The DOJ implies this creates an unnecessary barrier between the buyer who wants to view homes and their ability to freely choose and evaluate real estate services. Okay. The next comment they said was that it is about consumer choice restrictions. It forces consumers into formal agreements before they can even begin the basic process of viewing homes. And it also limits consumers' ability to test drive different brokers or services before committing. We know that stuff, but they're just pointing it out. However, NAR does not agree with these statements. So just telling you what I think is going to happen. My own personal opinion is this isn't over yet. Like we're going to keep having to hear about this stuff. But in Texas, they're allowed to choose and go and to a showing because we created just the showing form. It doesn't obligate them to be represented. It allows them to see the house. Now, we would like to develop the relationship while we're showing them homes and going through that to get them into the full representation form, but that's not what the showing form is about. The showing form is, I am allowed to show you this home. So that's the short form that we talked about last time. The long form is the long buyer tenant representation agreement, and that spells out your fiduciary duties to your client, their duties to you, and that creates that relationship. So in Texas, I got it. In Texas, we already have that form, but all across the country, because this is a national lawsuit, some places don't do it like that. That forces consumers into formal agreements before they can even begin the basic process of viewing homes. Yes, it does, but the agreement is that I'm going to show you this home on the short form, basically. Now, NAR says, this is a report from Housing Wire. So with just hours to go before Judge Stephen R. Bowe holds a final approval hearing for the National Association of Realtors Commission lawsuit settlement agreement, the trade association has fired back at the statement interest filed Sunday by the DOJ. In its filing, NAR mentions that the DOJ statement of interest is non-binding and says nothing that prevents final approval of the NAR settlement as written. NAR also addresses the DOJ's concerns about mandatory buyer representation agreements, which are now required for all Realtor members based on the terms of the settlement. In its statement of interest, the DOJ claims that the provision itself raises independent concerns under the antitrust laws, and that the agreements have the potential to limit how brokers compete for clients. In its filing, NAR called these concerns unfounded and claimed they are based on misreading of paragraph 58(6) of the settlement. According to NAR, the paragraph referenced by the DOJ makes the requirement for mandatory buyer representation agreements contingent on all state and federal laws and regulations. Due to this, NAR writes that there is no need for the parties to eliminate the provision as the antitrust division requests. As written, it already is expressly subject to state and federal law and regulation. Additionally, NAR writes that the provision, which the DOJ claims bears a close resemblance to prior restrictions among competitors that courts have found to violate the antitrust laws in other proceedings, does not at all resemble these practices. Okay. Buyers are free to hire a broker or not whenever they want. Buyers who want to engage a broker are free to hire whatever type of broker they want, the filing states. It just saying that it requires if a buyer wants to work with a broker, the buyer and broker must put their negotiated and agreed amount of compensation in writing before the broker brings the buyer into a home. Despite its rebuttal against these claims, NAR does not deny that the DOJ could potentially take action against it in the future. But NAR also contends that this is not an issue for the court to decide at the final approval hearing. The Antitrust Division can continue to enforce the antitrust laws, and a court can make a decision on any hypothetical future disputes at that later time. The filing concludes. So we just have to abide by what the Texas rules are. And right now in Texas, we have to be a member of the local association, the state association, and the national association in order to have MLS access. Now let's talk about things that have changed. So there are new forms that they just updated, and the mandatory effective date of these new forms is January 3rd. So it's not that bad though. They only changed a few things and they removed a form that I'll tell you about in a second. So I'm going to go over the updates of the forms. So basically in all of the residential contracts, they just added the word geothermal to the definition of natural resource leases. So if you have been in the industry for a little while, our contracts used to be like 5 pages and now they're like 11 because of things like this. Like they keep adding things to specify what that phrase means, because not everyone understands a natural resource lease. But now if they know it says geothermal, then that means it's included in the natural resource lease addendum. The next one is a big deal. This one we're going to have to talk about. Paragraph 60 is amended to include the option of providing the T47 declaration in lieu of the T47 affidavit when the seller furnishes the buyer with an existing survey. You know, right now, when you have a new construction and you have a survey and no one's lived there and you get the new survey, and then that's great. But when that person goes to sell, if they want to use the same survey to sell and provide that to the new buyer, they need to attach a T47 with it. A T47 is a document that says, we haven't changed anything about this survey. So the T47 has to be notarized now by the seller saying we haven't changed anything about the new survey. In the new contract, it's just saying that it doesn't have to be notarized anymore.
You just have the option to still use the affidavit, which is what we've always been using, and your client will have to have that notarized. Or you can use T47.1, which is the declaration. That one does not have to be notarized. If you, and the way that they make it so that people declare that that is them actually signing it, that they have the right to sign it, is there now is a birthday. It asks for the signer's birthday on there. So if they ask for the signer's birthday, now some people might not be comfortable with that because they don't want their birthday floating around. So in that case, then I would tell them, look, you have this other option to use the T47 affidavit, but you will have to have it notarized. You have to take it to your bank or the UPS store, wherever you can find a notary. So if they want to use the declaration and put their birthday on it, they can sign it through Dotloop, and that's all you need to know. They don't have to go through and go out and find a notary.
But if you come to a property that has a survey and then they told you that they built a patio or they built a pool, then you have to get a completely new survey. So the T47 is not needed in that instance.
I just remember the declaration does not, D&D does not need a notary.
Declaration does not need a notary. You just have to put your birthday. All right, paragraph 62 is amended to read buyer may obtain a new survey instead of buyer shall obtain a new survey.
Clarification on that. If your people have a survey and they need a T47, if they have a survey, even if there's change, get the T47 where it says nothing has changed except, put the except and draw it in, because what matters is if the title company and lender accept it or not. They're not necessarily going to automatically require a new survey.
Yes.
Make the changes and provide it, because if you provide it and it's rejected, then it comes to does buyer or seller. That's that second part of that.
Yep.
And that's part of that contract, why it says seller to provide survey and T47. And then the next part of that same paragraph says, if it's not acceptable to title company or lender, buyer will pay for it or seller will pay for it. That's why that clause is there.
It also says that if the buyer ultimately fails to obtain the survey, the buyer does not have the right to terminate the contract under paragraph 2B of the third party financing addendum. Paragraph 6E11 is added to provide information regarding mold remediation certificate requirements except in the unimproved property contract. That means if the property has been remediated for mold, seller must provide information about that to the buyer. So if you know that, then let that flag in your head that you need something else in addition to them just signing the form. And then paragraph 6E12 is modified to add specific examples of the types of notices that should be listed in the paragraph, and to add a caution that the seller's failure to provide required notices may provide the buyer with certain remedies, like the ability to terminate the contract. Now, they've took out MUD, WCID, and PID, but they've added utility, drainage, and public improvement districts, but the MUDs and the PIDs are public improvement districts. So it's still in there, it just didn't list them that way. So if you know that there's anything that has to go, that's going on with that property that needs to be conveyed, here's a list of that. But if there's more than that you find out, then you would provide that as well. But here's just the list of what you need to be aware of.
So everybody in here knows how to verify their taxes. Always make sure whenever no matter what side you're on, pull up the tax rolls and then look at the jurisdiction. So it'll itemize what, you got a county, a city, usually a hospital, some kind of municipal, some kind of local. But then you start seeing additional line items on there, and sometimes they're very clear. It'll say PID, it'll say MUD, but sometimes they're not clear. And if that question mark is in your head, reach out to an escrow officer and ask them to, hey, can you confirm whether or not this jurisdiction is a statutory tax notice? According to paragraph 6E3, anything that's an additional tax that's beyond the normal, it must be disclosed and in writing prior to execution of the contract.
So add to your checklist of things to do. Step 1, pull the tax records, print it out so that you have that about the property that you're going to be either presenting an offer or listing. And you want to check all of those. Perfect. The next one, this is the big one. We had to fill out the addendum regarding broker fees as of the last time we did a town hall until 2 days ago. 2 days ago, they took the addendum regarding broker's fees out of our list of documents that we can use because they've updated the contract to the new version and it's included in the contracts now. So you don't have to use the addendum regarding broker's fees anymore. However, just like today, Rachel has a contract that she is working on executing that is not a new contract. So she will need to use the addendum regarding broker's fees because it is not included in the contract. The new contract date is like 11/2024. The old one is like 11/2022. So you're probably going to miss it. But the way that you find out is if the settlement and other expenses has this paragraph in it, and then you don't have to use the addendum regarding broker fee. If it doesn't, you need to not use that contract. You need to tell the other agent on the other side of the transaction that that is the old contract and we can no longer use the old contract as of January 3rd. Okay, so let's talk about it. A1, seller shall pay the following expenses. A1 says seller shall pay the following expenses. Releases of existing liens, including prepayment penalties and recording fees, release of seller's loan liability, tax statements or certificates, preparation of deed, 1/2 of escrow fee, brokerage fees that seller has agreed to pay, where would you find the brokerage fees that seller has agreed to pay? Yes, the listing agreement, because the seller has agreed to pay brokerage fees to an agent. The other expenses payable by seller under this contract. Then B says, seller shall pay the following expenses. B, the following amount to be applied to brokerage fees that buyer has agreed to pay. Okay, where would you find the amount that buyer has agreed to pay? The buyer's rep agreement. Right. So if the seller says that they want to pay a portion of the buy or all of the buyer's part of this deal, then you put it in B. If the seller says, I'll pay 2% of the buyer's fee, but your buyer's rep agreement says 3%, the words applied comes into play there. The seller will pay the amount to be applied to the brokerage fees. So the seller's going to pay 2%, the buyer is going to pay 1% of the buyer's agent's fees if your buyer's rep agreement says 3%. What if you don't want them to pay 3%? You want to just take the percent that the seller is offering. What do? Amend it. You amend your buyer's rep agreement. So everything's amendable, right? But to start off, you want to put whatever amount is of your fees into that agreement. You can amend it up, you can amend it down. So that's where the amount goes that the seller is willing to pay for the buyer's agent. Make sense? Then C changes to the seller shall pay the following expenses, an amount not to exceed blank to be applied to other buyer's expenses, which are like settlement costs. Like if they want to do a seller's contribution to the buyer, that's what goes in that blank. So the first blank, let's say the seller agrees to pay $2,000 towards the buyer's agent fees, and they're going to agree to pay $5,000 to the buyer for concessions. So the 2,000 would go in B and the 5,000 would go in C for a total of $7,000 that the seller is agreeing to pay towards this transaction. And then number 2 is the buyer shall pay the following expenses. And they just added brokerage fees that buyer has agreed to pay, which is outlined in your buyer's representation agreement. This is the biggest change. So this is what I wanted to make you guys aware of. This is why we no longer need the addendum for broker's fees added to the contract, because they put it here.
So I know we were kind of taught, you send that form before you go under contract. So you make sure you get so now we don't.
No, you can still do that. That's still like the compensation agreement between brokers or the compensation agreement between broker and owner. So if the seller is saying, okay, let's say that Tanya is the listing agent and Tanya negotiated on her listing agreement that she charges X% and she is going to pay Y towards another broker, then that is on her listing agreement. Therefore, the buyer's agent would be able to do a compensation agreement between brokers, because out of Tanya's X, she's going to give Y to the other party. If Tanya lists the property and the seller says, I don't want to do anything with buyers right now, it's negotiable. So Tanya charges X, but she's not paying Y to anyone. So then the buyer's agent would need to go to the seller and say compensation agreement between broker and owner. And then you could get that amount. And if she says it's negotiable to the contract, then you wouldn't do the compensation agreement at the beginning. You would just put it in this section. And then the seller would agree or not to what this contract says. Then you negotiate it that way. If Tanya's paying the other broker out of her total listing commission, you don't need a broker's amount here, because Tanya is the one paying that. So some brokerages are not doing that anymore. Some brokerages are saying, I'm not going to pay another broker at all. You have to put it in the contract.
Trisha, I have a question.
Yes.
So I have this situation right now where I actually have an offer on a listing, but the buyers are just asking to not have the seller pay any commission, and they just want to pay, they're paying their buyer's agent separately. They want that amount taken off the purchase price. But they are asking for seller concessions. Do I need to find out how much they're paying their agent and put it in that amount, or can I just give them the concessions they're asking for and let them pay their agent however they're paying them?
I would ask them to present the offer with all that they are asking for, and then you'll talk it over with the seller.
Okay.
And then we don't need to know how much they're paying, what they're getting paid
Right.
on
They're
the other
asking
side.
for
Like,
X amount in concessions, and it's not really my business how they spend it. Like, they can pay their agent, right? However much they want. Okay.
exactly.
Okay. It would only be different if I were, because I'm obviously going to amend my listing agreement because we were going to pay. But then I'll just put, 0, and now they can do whatever they want with it.
The next thing is, this is a big one. On the bottom of the informational page where it says, what's your broker name and what's your license number, and then what's the other broker's name, on the bottom, there's this little sentence that says, pursuant to a previous separate agreement, listing broker has agreed to pay the other broker a fee. This is informational only. You can't just put 3% there and hope that you get 3%. It has to be in the other agreed upon contracts before. This is just informational to know, oh, this one's a 3% deal. Well, that 3% needs to match another document where they agree to the 3%, if that makes sense. So I get questions all the time. Well, I'm just going to put 3% there. And I'm like, well, no, because it hasn't been agreed to. So whatever number goes in that blank is whatever is already on another form. Got it? Okay, there is some changes with the third-party financing addendum. Paragraph 2A, the buyer approval has been changed to require both a notice of termination and a copy of written statement of the lender's determination, like in paragraph 2B, property approval. Because how many times have you had a buyer that said, sorry, we can't get lender approval, so we're going to terminate? Well, no, you can't. You can't do it that way. I mean, we can go back and say, we need a letter from the lender. That's what we used to do. Well, now you have to. Now you have to have a letter from the lender if they terminate based on they can't get financing. The buyer, it says, if the buyer terminates the contract under this provision, this contract will terminate and the earnest money will be refunded to the buyer. If buyer does not terminate the contract under this, the contract shall no longer be subject to the buyer obtaining buyer approval, and then they would be in default because they didn't provide both the termination and the letter from the lender. Okay, and then they changed the wording on B where, okay, first of all, I love the third-party financing addendum just because it is the two biggest outs that you have for your buyer that you need to be very aware of. The first one is that if they don't get a financing on their person, they don't get accepted because of their history, their credit score, their whatever, because of their stuff. The second one is B, is property approval. And that is a completely different thing that has to be approved. It's the house. And if the buyer lenders determines that the property does not satisfy lender underwriting requirements for the loan, the three things that we look at are the appraisal, insurability, and lender required repairs. Then the buyer may terminate this contract on or before the third day before the closing date. So it's still 3 days. You still have to terminate 3 days prior to the closing date. They just changed the wording to on or before the third day before. That's good. But so just put in your mind like 4 days. 4 days before the actual date, that's the date that I need to terminate by, just to make sure everything's fine. If you wait till the day before closing and you get your appraisal back and they're like, oh, it didn't appraise, sorry, we're out. You can't terminate. The buyer's in default at that point because it wasn't 3 days prior to your closing date. So don't let that date go by without knowing it's insurable, the lender is not requiring repairs, and the appraisal came in good. So if you get to the point where it's like, oh man, that day is tomorrow and you don't have the appraisal, what would you do? Give me an example. Call someone. Yes, that's great. Amend it. Amend the closing date because you're no longer protecting your clients if you don't have that stuff there. You have to amend it so that you can get more time to get the appraisal in. The amendment to the contracts changed just to match the new addition to the contract. So they've added paragraph number 4, the amount in paragraph 12(1)(b) of the contract is changed to, and then the amount in paragraph 12(a)(1)(c). So remember, B is buyers, what B is buyers and yeah, B is buyer's agent commission, C is concessions. So that's how we can remember that, so that when you're filling out the amendment, there's 2 blanks now for those changes instead of the 1 blank that was typically there for sellers concessions. Backup contracts, yay. This clarifies a little bit about backup contracts. So in paragraph 11, special provisions is modified to provide more clarity on the timing and payment of the earnest money and option fee by incorporating similar language from paragraph 5 of the contract and by addressing timing and payment of the additional fees. So when you put in a backup offer on the 1 to 4 family contract, it says earnest money and option money are this much and to be delivered here. The next sentence says additional earnest and option money shall be delivered here. Most of the time we don't do anything with that because now if it's a backup contract, you're going to go to the addendum for backup contract to add to that contract and it'll spell it out here for you. So it says the contract to which this addendum is attached is binding upon execution by the parties, and the earnest money and option fee must be paid as follows. Buyer shall deliver the earnest money and option fee as provided in paragraph 5 of the backup contract. And buyer shall deliver additional earnest money of blank of an additional option fee blank to escrow agent within blank days after the amended effective date of the backup contract. So the amended effective date is what?
is
Tell-
the day that your contract moves into first place.
Exactly.
Yay! Woo!
And so everything, all the contingencies reset and that day becomes day zero for the purposes of performance.
Okay, so if you're confused, it's confusing, but the thing is, you don't want to put all of your earnest money and option money into the backup contract because your backup contract may never become first place. And you have to pay the option fee and you have to pay the earnest money upon execution, even of the backup contract. So what you want to do is in paragraph 5, where it says earnest money and option money, make those low amounts, like $10 for the option period and $100 for the earnest money. Does that make sense? Then in this form, where it says additional earnest money, that means when your contract becomes first place, now you're going to really pay the amount that you would have paid for the option period minus 100. Yes, ma'am. And then the amount that you would pay for the earnest money minus the $100 that you put down on the original when you delivered it originally. And that's where that information goes. So let's say there's a house that's $350,000 and you're going to do $3,500 of earnest money. So on the first contract, you would put $10 for option fee and $100 for earnest money. On the second part, additional, it would be $90 if you want to do a $100 option fee and $3,400 in additional earnest money so that it adds to that total amount that your client wants to put down. And then it spells out when they can deliver that. If the last day to deliver additional earnest money or the additional option fee falls on just like normal weekend, you will get the day, the next business working day to deliver that money. But remember, if the option period falls on a weekend, it ends on a weekend. So the gray area with that situation is when the option period ends on Sunday and they haven't even delivered the earnest money or option money yet until Monday. Well, you don't have an option period really to back out until you deliver the money. So if you get in that situation, don't get in that situation.
Right.
Have them deliver it or pay for it on the Friday before so that you can back out by that Sunday without any problems.
Why
And
is it so urgent? If they don't deliver the additional earnest money, what happens? The seller has the right to terminate.
right. And that's one of the only thing that the seller can terminate for is because you didn't deliver the money. Okay, the amount escrow agent receives under paragraph of this addendum shall be applied first to the option fee, then earnest money. The buyer authorizes escrow agent to release and deliver the additional option fee to the seller at any time. Failure to timely deliver additional earnest money. This is what Robert just said. If buyer fails to deliver the additional earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both. And then failure to timely deliver additional option fee. If buyer fails to deliver any required additional option fee with the time required, the buyer shall not have the unrestricted right to terminate. This one, if you deal with 1031 exchanges, I guess that's been popping up a lot more, so they make a form about it. So now there's an addendum that is notifying that if that property is going to be involved in a 1031 exchange, you need to have this form to tell everybody about it. Okay, that's all I have for y'all. If you need anything, call me.